Hello and welcome to the Rogers Brief for March 3rd, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. This week I'm going to cover a few stories out of the United States. There was a couple of really interesting cases. Well, one case is this front page of the New York Times story this morning. Alex Murdaugh, a lawyer, disbarred lawyer out of South Carolina, that was found guilty of murder. That was a big story in the States. Not sure if people have been following that up here, but it was getting a lot of press down there. And then there was this other story of a grand jury foreperson in the Donald Trump saga, Georgia-based grand jury, special grand jury. And this foreperson has been going out doing a bunch of interviews. So I'll talk about that a little bit. Some Nova Scotia news as well. There's been a new court protocol in place. I'll briefly touch on that. And as well, the two big Canadian legal news stories this week. Two of them, one is the Justin Bourque appeal. This was the killer of three RCMP officers back in 2014 in Moncton. And his case, his sentencing was in the Court of Appeal, and there was a decision released this week, which has garnered a lot of reaction across the country. And then the other case, the other situation, I guess, is the election issue with the potential interference. Well, alleged interference as far as CSIS is concerned by the Chinese government against certain candidates or in favor of certain candidates in the last couple of federal elections. I want to talk about that in the what's called the Critical Election Incident Public Protocol that was supposed to protect us from these sorts of things. So I'll talk about that a little bit, and we'll get to all those in a minute. First, just a couple of stories that are very brief that I want to touch on. One was this story came out a couple of days ago that retiring RCMP Commissioner Brenda Lucki was going to be attending a World Police Summit conference in Dubai in March 7th to 9th, so just next week. But and she was going to be speaking on two panels. By the way, a little peculiar. Anyway, I'm not sure why a conference of that nature would be in Dubai. I'd be curious to see what their police is like in there, and well, maybe they're trying to get some examples from the rest of the world. Anyway, Commissioner Lucki was to be speaking on two panels. One was called the Commissioner's Session on Trust, Fairness, and Resilience, the Evolving Dynamics of Police Leadership. And the second one was on handling mass casualty events. All right, so this when this came out as a news piece on CTV, I think there was quite a bit of reaction, like, why is she going to be saying anything about these things, where many would say that the police did not handle the mass casualty event very well in Nova Scotia. Certainly handled a little better the more recent one in James Smith Cree Nation in Saskatchewan. Anyway, so then a day later, CTV was reporting that Commissioner Lucki, in fact, was not going to go to this summit for personal reasons. The personal reasons I can only imagine being that the news came out that she was going, and then people were going to pay attention to what she was going to say, and that was the personal reason why she decided not to go. Too bad, in my view. I would have been very curious to see what she would say about these kinds of things. We noticed during the Mass Casualty Commission that, and there were exceptions to this, but it seemed in some cases that those who retired from the force, who were on their way out, felt a little more free to speak about these kinds of things. I think Brenda Lucki would have been a very interesting speaker on those two topics, and it's too bad that she's decided, or was probably pressured into, not going. All right, so that was one story. The second one, just a sort of Nova Scotia thing. Coming out of the pandemic, a lot of issues with virtual court appearances. This was done during the pandemic, and it was a very efficient way to get things done. Routine matters were handled over the phone or by Microsoft Teams, virtually by video. So there was less travel time involved. All of these things done very efficiently. Well, the Nova Scotia Supreme Court has decided to keep some of those efficiencies for certain routine matters, date assignment conferences, case conferences, routine updates. So that will make things a lot easier for the courts and for lawyers and clients who are in the Supreme Court system. I suspect the provincial court, in my experience at least recent months, they've been using virtual court fairly often, even for non-routine matters, and it's been working quite well. So I suspect the provincial court is going to follow suit and have a protocol. So what it is, basically, this is the default position for certain matters. It's laid out whether it's going to be on the phone, in person, or by video. So good thing for the courts to be making that clear to everybody what methods are going to be used. All right, so people have been following this case out of the United States. I'm not sure. It's right out of a John Grisham novel. This Alex Murdaugh, a South Carolina lawyer. He was 54 years old, fourth generation, described as a legal dynasty, this family of lawyers. They've looked like controlled the prosecutor's office at a big law firm, very successful family of lawyers, up until this guy who was disbarred, who was stealing money from his firm, from clients. 8.8 million was one of the figures listed. Well, he was charged with the murder of his wife and his son, his adult son, young adult. But so the question is, can a lawyer get away with murder? Could he do it? They didn't find any weapons. They didn't find blood evidence or any kind of that DNA stuff on him. He had an alibi of sorts, which was that he was, as close as they could figure to the time of death, visiting his mother, who lived, his ailing mother, old elderly mother, who lived 15 minutes away. So there was some evidence of that. And it looked initially like he might be getting away with this. Like I said, he was a thief. He stole money from clients, from his firm. He was also an opiate addict and had lots of issues that way. So things, in a sense, were going well for Alex Murdaugh, but then they managed to get into his deceased son's phone and found a video that had been recorded just minutes prior to all of this, to the attack. They were both shot, so it was a sudden killing. And the video was around the dog kennel that they had on their property, and you couldn't see Alex Murdaugh, but you could hear his voice, and so that placed him on the scene. And so Alex Murdaugh had taken the stand in his own defense, was confronted with this evidence of, well, here's your voice, sir. You said you weren't there. Here you were. And that was about it for him. Jury took 3 hours to come up with a verdict, which is very quick. Possibly they might have had a meal during that time. It looked like a very easy decision for the jury to make. The defense team, who had gotten very emotional during their closing arguments, crying at one point, the lawyer that is, making the closing arguments, saying, imagine coming back to this scene, because their case was he had been to his mother's and came back and found this grisly scene and suspected that there was no evidence of anybody else that would have had an opportunity. So it was very clear that it was Alex Murdaugh that did it. But they, got all emotional, called for a mistrial immediately afterwards, and the judge in the case said no, he wasn't going to agree or allow that at all, and said that the evidence was overwhelming against Murdaugh. So interesting case. If you haven't followed it, haven't looked at it, be something to look up. This Alex Murdaugh case. Another bizarre twist. After he kind of figured he might be caught, he apparently tried to get a distant cousin of his to kill him, and in the hopes that whatever money was left in the estate would successfully go to his surviving son and insurance funds, life insurance. That didn't work out either. He had I don't know exactly what happened with the attempt, but the cousin shot at him, but didn't kill him. So That's can't seem to do anything right, that guy. Okay, that was one story out of the U.S. The other one is this Donald Trump's special grand jury out of Georgia, and this is a grand jury, a little different in the United States. In Canada, if you're charged with a crime, you have an indictable serious offense, you have an opportunity for a preliminary hearing, which is a hearing to determine if there's enough evidence to go to trial. The U.S. is a little different. They take it to a grand jury, provide them with the evidence, and if they decide there's enough evidence to indict somebody and have them charged, then they will be charged. This was a little different, as a special grand jury in Georgia into election fraud, wondering if former President Trump had pressured the Attorney General officials in Georgia into trying to effect some election fraud, finding votes is the allegation. Okay, so they go to this grand jury, which is supposed to be a very secret process, much like a criminal civil jury that you're used to thinking about. And so they provide this evidence, and it was to provide recommendations as to whether charges would be laid against the former president. And this foreperson, Emily Coors, has been going and doing interviews afterwards. And she seems very starstruck by the whole process, getting her 15 minutes of fame, hinting that indictments are being recommended. Now, there are other people that could potentially be subject to those indictments, not just former President Trump, but others. But it seems quite likely that this grand jury, from what her interviews are revealing, is going to recommend indictments against the former president. Anyway, so I thought really interesting just to show the difference between Canada and the United States in terms of juries. Judge Robert McBurney of the Florida Superior Court told the grand jury, that their deliberations are secret, but they are allowed to publicly discuss evidence that they heard, and they can also discuss their final report once that is issued, but not the deliberation. So it's a very fine line, which would be safest walked by not walking it at all and not giving interviews, but this foreperson is, and it's really, I think, having the effect of undermining the process. I mean, there's a reason why those deliberations are kept secret, so it allows people to say whatever they think and not feel like they're going to be, subject to outside pressure or consequences depending on how they perform, in a sense, during their deliberations in a jury. In Canada, it's an offense, a criminal offense under Section 649 of the Criminal Code for a juror to disclose anything about their deliberations. My research tells me this stretches back to 1785, the Lord Mansfield's rule out of Britain. Now, a special grand jury is not the same as a regular jury, but the rules are more or less the same. I mean, you have to keep your deliberations secret. Nothing about what you say nothing about what is said while the jury is deliberating can be revealed. Nothing that discusses how you were influenced by anything that took place during the trial, what you thought was good evidence, solid evidence, credibility questions as to certain witnesses. All of those things are not to be revealed by any jurors, and you'll see in Canada, you'll never see a juror being interviewed after the fact. And the risk is, of course, that they would be charged with a criminal offense. So much different, and boy, just another example, I guess, of how things are so different down in the United States. All right, so that is that, but next story. Next story is the story in Canada now of the election interference allegations. And what we've heard this week from CSIS officials, leaks from CSIS, and been revealed in the Globe and Mail and other news outlets, is that officials with the Chinese Communist Party, Chinese government, were trying to help out certain Liberal MPs or candidates become MPs, and spreading bad news or bad reports about conservative policies and candidates. And so the question is, well, why are we only learning about this now? Because one of the other things that came out is that CSIS had told the Prime Minister's office that this was happening and had recommended that the certain Liberal candidate in the Ontario area, Ontario riding, be rejected as a candidate, which the Liberal Party didn't do. And then also we didn't hear anything about this. Well, a couple of elections ago, there was this, well, this was after the James Comey FBI revelations, that talking about Hillary Clinton's server and all of these, allegations of Russian interference in the U.S. election back in 2016. And so the Canadian government set up what they called a critical election incident public protocol, which sounds like a serious thing and a law, but it is not a law. It is a cabinet directive. So it is something that cabinet sets up and they want a report, but it's not a law with the kind of consequences that you would expect from something that's been legislated or a regulation that could be violated and there would be consequences. It was designed to give guidance to civil servants during what is called the caretaker phase of a government. So during an election campaign, the cabinet is still an active cabinet. If you're the Minister of Defense, well, you're still the Minister of Defense, even though you're running for office and running in the election. So the problem is, all right, what is interference sufficient to go public? Well, the three factors they're supposed to consider, this committee of civil servants, is one, the degree to which a free and fair election is undermined by whatever activity is taking place. Secondly, the potential to undermine the election's credibility. And thirdly, the degree of confidence in the information itself. Well, the information was coming from CSIS. There was a high degree of confidence. The issue, okay, so there was lots of confidence in the information, but what the committee has revealed or suggested, the government has, is that the problem was not widespread enough to affect the country-wide result. Well, I'm not sure that that is the correct standard for this committee and the protocol. Because, all right, well, if it's not going to affect the overall outcome of the election, if it's just one or two seats, well, actually that could potentially affect the overall outcome. So I don't think that's a correct interpretation. If something has an impact, a potential impact of affecting one riding, that should be revealed as well. And if there's outside interference that's improper, don't see any reason why that wouldn't be revealed during the election. I think voters in each particular riding where that might be taking place would want to know this kind of information beforehand. So there's some recommended changes and clarifications. I would say that this should be clarified so that smaller scale, in a sense, incidents of interference should also be revealed publicly to the voters so that they can make a decision properly on what is actually taking place. Okay, so we'll watch for that. I'm sure that's going to continue to be in the news. Pretty serious to see outside interference. I know there's been calls for a public inquiry into what took place and what kind of attempts the Chinese government or elements of the Chinese government are trying to make in Canadian elections, because we're going to have another one in the next couple of years probably, and we want to make sure that that's done without any such doubts. Okay, last story I want to cover. This is another big one this week in Canada, and this is the Nova Brunswick Court of Appeal decision in the Justin Bourque sentencing. Now, Justin Bourque, those who don't remember now, Justin Bourque's name came up a few times during the Mass Casualty Commission because the report from that incident back in 2014, where Justin Bourque, he killed 3 RCMP officers, wounded seriously 2 others, and was at large. It took police 28 hours to capture him in Moncton. He was walking around a subdivision. He was in camouflage. He had firearms. He was hiding. So that was June 4th of 2014. Pled guilty on August 8th of 2014 to the first-degree murders, 3 of them. And so he was sentenced that fall by Chief Justice Smith of the New Brunswick Supreme Court, Chief Justice at the time, to life in prison for each first-degree murder offense. And in each case, then there was 25-year minimum time for parole eligibility. So life in prison, in a sense, doesn't mean the rest of your life. It means life in prison, but you would be eligible for parole, that is, release under conditions after a period of time. In this case, the court determined that the 3 25-year time frames should run consecutively. In other words, that Justin Bourque wouldn't be eligible for parole for 75 years, which I think, if I read correctly, would mean he would be eligible when he was 99 years old. Unlikely to reach that age, but in any event, if he was 25 years, it would be eligible at about 50 years old. So the appeal got a lot of attention politically and in legal circles this week, but in fact it was quite a routine matter in a legal sense. It was a really simple and clear appeal. It wasn't really argued by the Crown. Normally when he was sentenced back in 2014, normally you have 30 days to appeal your sentence. But the reason this was in the news was in Quebec, this Alexandre Bissonnette in January 29th, 2017, murdered 6 people and seriously wounded 5 others in Quebec, and he was sentenced to life in prison with no eligibility for parole for 40 years. Okay, so in that case, the Quebec Court of Appeal found that the parole ineligibility should be concurrent. In other words, the 25-year maximums should run together, and declared that the law that was brought in by the previous Conservative government, Section 245.51, was unconstitutional. That section allowed parole ineligibility timeframes to be concurrent. Quebec Court of Appeal said that that was unconstitutional, and it went to the Supreme Court of Canada, and the Supreme Court of Canada agreed with that. Okay? So what the Supreme Court of Canada said is that this long period of ineligibility for parole effectively deprives the offender of any realistic possibility of being granted parole before they die. So that is degrading in nature and thus incompatible with human dignity. It presupposes definitively and irreversibly that the person lacks the capacity to reform and re-enter society. And so under Section 12 of the Charter, which is the section that guarantees us to be free from cruel and unusual punishment, that this was declared unconstitutional. All right, so what they say is that Parliament, the Supreme Court of Canada said in Bissonnette, that Parliament may not prescribe a sentence that deprives every offender on whom it is imposed of any realistic possibility of parole, even in cases like first-degree murder, and they point that out, where rehabilitation is an objective of minimal importance. They don't care if these people are reformed, they just want to have them in jail. It says, and the Supreme Court of Canada said that the imposition of sentences of excessive sentences that fulfill no function, so does nothing more than bring the administration of justice into disrepute. You know, it's like splashing somebody who's underwater, right? It does nothing, and everybody involved looks a little silly. I mean, if you sentence somebody to consecutive life sentences, you know, beyond the average or maximum lifespan of a human being, well, what are you doing, right? They're never going to serve that sentence. So it just undermines the integrity of the justice system by doing so. So 25 years, and then it's not like people are going to be released automatically after 25 years either. It goes to the parole board at that point, and, you know, if the person is still dangerous and not considered reformed and the parole board doesn't agree that they're ready for release, then they're not released. Or if they're released under certain conditions, strict observation, then they can be released. You know, just happened that this week, again back to the United States, but It could happen in Canada as well. Senator Robert Kennedy, who was possible president, his assassin, was denied parole for the 17th or 18th time he applied. He's been in jail for 55 years since 1968, and so not like these people get released automatically after they're eligible for parole. Justin Bourque, he's completely unreformed, and there's lots of opposition, as I'm sure there will be. As a 50-year-old, when he's eligible for parole, I'm sure they'll take a very close look at that, and whatever outrage we've seen this week, expressions of outrage from people that were very upset by this Court of Appeal verdict decision out of New Brunswick this week. I'm sure they'll be there when Justin Bourque is eligible for parole I guess it'll be 40 years, 20 years from now. So we'll see about that. So like I said, the appeal itself was a very routine one. It was handled by written submissions only. There was no argument from the Crown. The Crown and the judge agreed that the decision of the Supreme Court of Canada and Bissonnette dictated. It was binding on the New Brunswick Court of Appeal, which is a lower court, of course, and so it was dealt with by written submissions. And in the course of their decision, I read the decision, it was 6 pages, only brief, that the Court of Appeal did make sure they noted the horrific nature of the crimes by both Bourque and Bissonnette in coming to this decision. And so they say, well, you can't have an absurdity in a sentence, and so this is as serious a sentence as as courts in Canada are permitted to render. So that's that. People can disagree as to how severe punishment can be in Canada. We don't torture people. There's a limit to there's time limits to certain offenses in sentencing, and so and it goes against human dignity to have just absolutely no chance, trying to predict 25 years into the future how somebody's going to be, what their personality is going to be like. That's a difficult thing to do, and something that is better left to people at the time, and that is the parole board at the time when the decision needs to be made. So that's an explanation of that controversial issue from this week. I thought it would be important for people to understand why that decision was made, and maybe cool the heat a little bit on some of the outrage that has been engendered by the New Brunswick Court of Appeal decision this week. Okay, so that is some interesting stories, some cases out of the United States this week. I thought I'd touch on those, and the election interference, big national issue in Canada this week, and the Justin Bourque decision as well. Big news in a sense, but a very routine legal matter as well. So that's it for this week. Thank you everybody for watching, and thank you for listening. If you like these videos, podcasts, be sure to like the video on YouTube, share it with others, and be a subscriber if you're not already. Okay, thanks again, and we'll see you next time.